All right, this is the first video lecture covering the material that was assigned on confidentiality and confidential communication and privileges. This recording covers PowerPoint 10. So the idea of privilege actually is one of the most interesting areas that we cover in evidence class. But as you saw, privilege is covered in the federal rules only by two rules, 501 and 502. We're going to look at those and talk about those in the course of these lectures. But I want to just say a bit about the idea of evidentiary privileges in general, talk about some of the policy reasons for the existence of these privileges in the legal system. I mean, we know now at this point of the course that there's lots of different rules that keep evidence out of trials, right? We have the hearsay rule, Rule 403. Those, for the most part, the underlying purpose is to keep out certain evidence that might be misleading or unreliable or prejudicial. But we also have other rules that are based on policy concerns. Remember Rule 407 on subsequent remedial measures, right? We don't allow evidence of those measures to come into court because we want to encourage people to take those measures without worrying that it's going to affect their chances of being found liable in a lawsuit. We also have, remember, Rule 408 covering statements in settlement negotiations, Rule 410 that keeps out certain statements in plea bargain negotiations. Those both rest on the policy decision that we've made to encourage those kinds of settlements. Now, with privileges, we're often making the decision to keep out very relevant and probative evidence that may not even be very prejudicial necessarily. We're making that decision, though, for a different policy reason, and that is that we want to protect and encourage specific types of relationships that we as a society believe require assurances of confidentiality in communications. And so we've decided that we are going to value those relationships enough to be willing to forego the ability to get at certain information that is otherwise relevant to fact finding in the legal system. So evidentiary privileges, therefore, limit parties' ability to demand or discover information about certain communications, and they limit parties' rights to interrogate or subpoena or call to the witness stand certain witnesses like doctors and spouses and lawyers. So for our purposes in this class, I want you to know the basics of the attorney-client privilege and the companion work product privilege that goes along with that, the physician-patient privilege and the psychotherapist-patient privilege, and the marital or spousal privileges, which are all represented here on this slide. So if we stop to think about clients' relationships with lawyers and doctors and psychotherapists and spouses' relationships with each other, it's pretty easy to see why we as a society have decided to try to promote and foster those relationships. And it's pretty easy to see that maintaining those relationships does require that communications that are shared between the people in those relationships be confidential and protected. All right, so we've decided we're going to value that over and above the truth-seeking value of the use of those communications and evidence in court. So a few more general points about privilege on this slide. Privileges fall into two main categories, those that focus on individual communications, right, like the attorney-client privilege, but also there are those that actually prohibit any evidence or testimony from being sought by an opposing party. For example, one of the two types of marital privileges, the spousal incapacity privilege or the spousal testimonial privilege. So with all of the privileges, I have on this slide four things that for sure I want you to pay attention to. So first, it's important to remember who holds the privilege, right? Because that's the only person in that relationship that can choose whether to claim the privilege or maybe even whether to waive the privilege altogether. So it's usually not a two-way street Although, for example, with California's confidential marital communications privilege, as we're going to see, in that one, actually either spouse can claim it. But that's a sort of a more unusual example. The next thing to focus on is when does the privilege apply? Next, what does the privilege cover? Does it cover only communications between people? And if so, do those communications have to be under certain circumstances or about certain things? Or does it omit protection for some kinds of communication? Also, how strong is the privilege? Some privileges are absolutely bulletproof, but others are considered to be qualified privileges. So if opposing party, for example, makes a specific showing to a court, it might be possible for a judge to order some things to be admitted. All right, so as you saw by looking at the rules that I assigned in the reading, there are only two federal evidence rules that say anything about privilege, 501 and 502. Rule 502 wasn't even put in place until 2008, so very recently. But just looking at where this law of privilege came from, well, it's actually very old. It originated in the English common law. And by the time the federal rules were finally promulgated in 1975 in written form, many states had already codified their own rules about privilege. And so by 1975, most of the states had statutes talking about all the different privileges. So the political history of the federal rules in this context is really fascinating. Initially, when the federal rules were drafted, that original rules committee did try to codify the rules as they had developed in the federal system under the common law. And in fact, they drafted 13 rules about privileges and sent them to Congress. But it turned out to be one of the most controversial aspects of the federal rule codification. So first, some professions that were left out of those privilege rules, like doctors and journalists, for example, lobbied Congress that they should, in fairness, also be included. So there was some fighting there. Also, there was an entire rule proposed by the committee protecting government agencies from having to disclose information that they termed to be state secrets. And that was very controversial too, especially in the aftermath of the Watergate scandal. Again, if you look at what was going on in the country in the mid-70s. So for lots of reasons, these rules were just political hot potatoes, and Congress just decided, look, we're not going to accept any of these codifications. It's just going to be more trouble than it's worth. So in the end, we were left with Rule 501 all by itself, which basically, as you saw, leaves privilege law up to the quote-unquote reason and experience of a judge as interpreted by the courts under Rule 501. So essentially, federal judges are expected to consult the common law to make rulings on privilege issues. Now here is Rule 501. So the first part tells judges to consult the common law unless the Constitution or a federal statute or another federal rule like a rule of civil procedure or criminal procedure override the common law, or unless a more specific rule is at some point prescribed by the Supreme Court. But then in this second part of Rule 501, you see that when a federal court is applying the state substantive law, right, like, for example, in a diversity case that ends up in federal court, the court there has to apply the applicable state privilege rules as well, in addition to state substantive law. So when a federal district court tries, for example, a personal injury diversity case, it's going to have to apply state privilege law. On the other hand, when it tries a federal antitrust case, for example, it's going to apply general federal common law using its reason and experience. Okay, so we're going to start with the lawyer-client privilege. That's certainly the oldest one, probably the one that has the fewest exceptions. Like I just said, though, most states have statutes regulating the attorney-client privilege, but it's certainly an interesting area because the actual implementation of the rules by courts really does come from case law and precedent and not just from, say, rigorous adherence to the particular language of the statutes, no matter what jurisdiction you're in. So certainly the modern day rationale for the attorney-client privilege is we want to encourage clients to confide in their lawyers so the lawyers can provide good advice, complete advice. Obviously that requires confidentiality. Now, I know you study attorneys' professional ethical obligations to protect client confidentiality in your professional responsibility class or ethics classes in preparation for that MPRE. So you study those rules of professional conduct. And certainly the model rules of professional conduct cover this confidentiality duty in quite a bit of detail. But the evidentiary privilege, the evidentiary attorney-client privilege is stronger because it does protect attorney-client communications even if a lawyer is subpoenaed to testify in court. But the evidentiary privilege is limited. While being a strong privilege, it's limited because it only covers confidential communications made to obtain legal services. So in that sense, it's narrower, more focused than attorneys' general ethical obligations around confidentiality. So on this slide, there's a good basic definition of the attorney-client privilege. Really includes the major areas you have to look out for when analyzing whether something is covered by this privilege. All right, so let's look at it. It covers things that are confidential and that are communications between an attorney and a client or their respective representatives in certain cases in the course of the professional relationship. Okay, so I want to go through the basics of what you're going to be expected to know for my purposes using this basic definition. First, it's the client who holds the attorney-client privilege, which of course makes sense because it's the client here whose communications need protecting. On the other hand, it's usually the attorney who ends up asserting the privilege on the client's behalf. First of all, clients don't usually know the rules about privilege. And also, of course, lawyers are the ones who receive things like discovery requests that would call for material that might be privileged. So it's assumed that lawyers have the authority to and will assert the privilege when it's necessary to protect that privileged material. Okay, next, when does the attorney-client privilege apply? Well, the attorney-client privilege is one that applies in any legal context you can think of. Obviously, it applies at trial, but also it applies at grand jury proceedings, during discovery, and every other possible stage of legal proceedings. So it's very broad in that way. Next, what does the attorney-client privilege cover? Only communications, for one thing, but also only confidential communications made for the purpose of facilitating the provision of professional legal services to the client. So starting with the word confidential in this context, it's easy to imagine a classic confidential communication, right? A consultation or meeting behind closed doors between an attorney and client. But communications in the presence of the lawyer's staff or in front of another person thought to be needed, to be helpful for that communication, like an interpreter, for example, or an accountant who's trusted by the client to help interpret complicated financial information, or maybe even a close family member who's there to help the client. Those should also be held to be confidential, communications in front of those people, as long as the client reasonably believes that the discussion is confidential and that the third person's presence was reasonably necessary in the furtherance of the consultation or meeting. On the other hand, third parties who are outside of that circle can compromise privilege. So communications intended to be covered by privilege should certainly not take place in front of strangers or other people whose presence could not be defined as reasonably necessary to further the process. So that brings up the question of eavesdroppers, like our telephone operator in that Clark case that you read. So as you saw in Clark, the old common law rule was that the client was out of luck if someone overheard a confidential communication. So an eavesdropper could testify at trial about something he or she overheard. But the modern trend in federal courts is strongly in the direction that as long as a lawyer and client intend communications to be confidential and they take reasonable precautions to keep them confidential, communications that are overheard should not be admissible, should still be covered by the privilege. And in California, I have an excerpt on the slide. Our code section 952 certainly seems to go along with that prevailing trend, saying that as long as information is transmitted in confidence and the client has no awareness that anyone else can hear, those communications are going to be covered by the privilege here in California. So this idea of client awareness is really interesting. There was a Fourth Circuit case, U.S. versus Lentz, that I have on the slide from 2008, in which a prison inmate called his lawyer and made incriminating statements on the phone about his pending case. And the conversation was recorded by the government. That was the policy of the facility. And the prison had made it clear to inmates, had given them notice that all of their phone communications were monitored. So in this case, the defendant was considered to have been on notice. None of these communications with his lawyer were considered privileged in this case. So just a little more information here about what communications are going to be considered not confidential. We already talked about the first one, anything said between a lawyer and a client in front of other people who are not included in that circle of people that we just discussed, who are not considered necessary or helpful to the communication, not going to be considered confidential. Also, anything given or said to the lawyer by the client intending that the lawyer make the communication public later. For example, information for a public filing of some kind might fall outside the privilege. So, for example, information communicated for a bankruptcy filing might not be protected by the privilege. And the last one, really interesting, if communications are made in a joint consultation with a lawyer, say by two best friends who are now forming a corporation together, they're going into business together, their communications are not going to be privileged if there's later a dispute between those two partners. Their communications with the lawyer would be protected by the privilege from disclosure to any outside party, but not as between the two of them if there's a later dispute. And the same might apply if a divorcing couple decides to hire just one lawyer together, hoping that they're going to be able to resolve their property division and child custody issues amicably. If those negotiations break down, not only does that lawyer now have to withdraw from representing either spouse, but either person can now call the former lawyer to testify about any communications between the lawyer and either spouse during the time they retain that lawyer jointly. So for attorneys, representing multiple clients can really be a dicey proposition. There has to be lots of disclosure on the part of the attorney before entering into that kind of arrangement. Okay, so the privilege only applies to communications, not acts or observations. For example, information about a client's physical appearance. That's not privileged because that's something that is just observed by the lawyer, not acquired through any kind of communication. So, for example, a lawyer can be forced to testify about a client's physical characteristics, dress, mannerisms, sobriety or lack of sobriety, anything that any other person could have observed if he or she had been present. This has also, in fact, been held by some courts to require a lawyer to testify in a later case about the mental capacity of a client. For example, calling a lawyer from a prior case to testify in a hearing about competency to stand trial. This is a pretty controversial issue. It's been argued by a lot of people that a lawyer would be, in fact, basing his or her testimony about competency or mental capacity on the communications that took place during representation. But this idea has actually gained pretty wide acceptance, maybe because of a kind of necessity, right? After all, who else is going to be able to speak better to a client's competency to cooperate and assist in his own defense, for example, than a previous lawyer? All right, let's talk now again about the fact that the privilege only applies to communications between an attorney and client or their representatives. So first, confidential communication with all the non-lawyers who work for the lawyer, like secretaries, investigators, paralegals, and clerks, are almost certainly going to be covered by the privilege, even if the lawyer isn't there when those communications happen. And then there's some other interesting situations worth discussing here under this part of the definition. First, most of the case law indicates that a client who seeks legal advice from someone who's actually not a lawyer, but who the client reasonably believed to be a lawyer, maybe because that person told the client he or she was a lawyer, those communications are going to be covered by the privilege as far as confidential communications made to that person. Next, one area that can be really tricky here is the situation where there are experts involved in a case, either to help with case preparation or to act as a testifying expert in a case. So when are communications to an outside expert covered by the privilege? This is quite complicated and certainly is also covered by the rules of civil procedure, but it usually depends on the nature of the work the expert is doing and who hired the expert. So we know there's lots of different kinds of experts that might be hired by a lawyer to help with case preparation, doctors, engineers, accountants, and so on. And the basic rule here is that if the lawyer is the one who hires the expert, and if the expert's only role is helping the lawyer to prepare the case, then communications between the client and that expert will be covered by the privilege. That is the general rule. But there are a couple of scenarios where communications with experts are probably not going to be covered. First, if an expert is going to be a trial witness, the purpose of the communication between the client and the expert is to prepare the expert to testify and not just to help the lawyer prepare the case and give legal advice. So that expert will be deposed about his or her opinion and the basis of that opinion, and that will include communications the client made to the expert, so probably not privileged there. Another situation where privilege probably won't apply is where the expert that is helping the lawyer also has an independent relationship with the client, separate and apart from the lawyer and or the legal case. In that circumstance, again, gets really, really dicey trying to draw those lines, trying to figure out whether communications are going to be viewed by a court as being for the purposes of their separate relationship, in which case they won't be privileged unless they somehow fall under another privilege, right? Not the attorney-client privilege. Or, on the other hand, whether those communications might be seen as, oh, these communications were specifically to help the lawyer here provide legal services. So very, very tricky. And a lawyer who wants to make absolutely sure that communications with an expert are going to fall within the privilege should not use one of those dual relationship experts for trial prep. Doctors are a classic example here. We know that even in jurisdictions that do recognize a doctor-patient privilege of some kind, communications between the doctor and a client party won't be privileged if that doctor is called by the party to be a witness. And in jurisdictions that don't recognize the doctor-patient privilege, communications with a doctor who is both helping the lawyer and treating, or who has in the past treated, the client patient probably also won't be protected. Okay, the last part of our definition of the attorney-client privilege makes it clear that it only applies to communications made in the course of the professional relationship, sometimes also stated as for the purposes of obtaining legal advice or services. So first, let's talk about what's not included in this. When a client is seeking business advice, political advice, personal advice from a lawyer, or when a client is also a friend of the lawyer and communications take place under the friend umbrella, those communications are not going to be covered by the privilege. So there are some classic hypotheticals that you might see on an exam. For example, there's the one where a lawyer has a client who's also a friend, and the friend calls the lawyer to say, "Oh, I'm contemplating suicide." That communication is not privileged if the caller later dies and there's litigation in which it's at issue whether the person died of a natural death or committed suicide. Classic exam hypothetical there. The other one is when a lawyer serves in dual roles, say as both a business or tax advisor and a lawyer providing legal advice. So if a question is asked or a comment is made in the course of discussing business options or tax strategies, and the lawyer is later called upon to offer an opinion on the advisability of that option from a purely business or tax standpoint, it's not covered by the privilege. On the other hand, if communications involve seeking legal advice, they would still be privileged even if there's also a secondary additional purpose of receiving business advice. So it is very easy to tell here this is going to be tricky to figure out. It is going to be very context specific, and lawyers that serve in these dual roles have to be extremely careful about how they proceed. This requirement that a client's communication be with the lawyer in the course of the professional relationship also means that any pre-existing documents of the client, they don't automatically become privileged when the client gives them to the lawyer. This makes perfect sense. I mean, you can't allow someone to insulate documents prepared for some other purpose by turning them over to his or her lawyer, right? The original preparation of that document wasn't for the purposes of communicating something to the lawyer, so it's not going to be automatically included in the privilege, and it's probably not, it probably is going to be discoverable by the other side if it's relevant. On the other hand, if a client prepares a document specifically for the lawyer, now that document is covered by the lawyer-client privilege, whether or not the underlying information in the document is secret or not. Also, just keep in mind here, any physical evidence or contraband that a client gives to a lawyer, that has to be disclosed by the lawyer and turned over to the other side. So can't protect that from disclosure by turning it over to a lawyer. A few more things I want you to know about the attorney-client privilege. The general rule is that the privilege survives the death of the client. You saw that in the casebook in the Swidler and Berlin versus United States case. Remember there was a challenge to this long-standing common law precedent, and the Supreme Court here declined to narrow that rule, in part because the court thought, look, only a clear, hard and fast rule is going to provide enough certainty to encourage clients to communicate full and frankly with counsel here. The only exception to this general rule does allow disclosure of a testator client's communication and intent in the context of disputes among heirs, say about a will or the intent of a now deceased testator. The Supreme Court distinguishes this right there in the Swidler and Berlin case by saying that this exception actually does protect client intent, and that is the reason for allowing that exception. Okay, so next let's talk about the application of the attorney-client privilege in the context of a corporate client, which you read about in the Upjohn case, and I think you do cover this case also in professional responsibility or ethics classes as well. So Upjohn is the one and only case in which the Supreme Court has dealt with this very complicated problem of the attorney-client privilege in the corporate context. So as you saw, in 1976, Upjohn, the pharmaceutical company, in the course of an internal audit, found out that some of its foreign subsidiaries might have bribed officials of foreign governments. So the general counsel there undertook an internal investigation of these possibly questionable payments, presumably with a view toward advising the company, determining the company's potential liability under various laws. So the chairman of the board here wrote formal letters to all the foreign office managers asking them to cooperate in the investigation by their general counsel, which began with a very detailed questionnaire they had to fill out. Now, this letter was very carefully written. It made it crystal clear that the company was gathering all this information for legal purposes and that all communications should be directly with the general counsel, and furthermore, that the investigation was highly confidential. Okay, then Upjohn voluntarily went to both the Securities and Exchange Commission and to the IRS to disclose some of those payments Upjohn thought might be questionable. The IRS, of course, imagining, hey, Upjohn probably owes us more tax money, right? Because presumably non-deductible bribes had maybe been disguised as deductible business expenses. So the IRS, once they find out about it, they launch their own investigation. They then demand that Upjohn turn over the files and information collected by their general counsel. The company, of course, claimed the attorney-client privilege here, and the Court of Appeals actually ruled in favor of the IRS. They used that control group test that had been followed in several circuits prior to this case getting to the Supreme Court. There had been a circuit split. The control test idea was basically that only the members of a corporation's control group, right, i.e. those in senior management positions who could actually act on the advice of an attorney, that only the controlled group fell under the corporation's privilege for their disclosures to the corporation's attorney. But as you saw, once this case got to the Supreme Court said no, a broader privilege is going to be needed in some cases in order to adequately encourage necessary communications to corporate attorneys. And the Supreme Court said, look, this narrow control group approach is going to limit the valuable efforts of corporate counsel to ensure their clients' compliance with the law. The Supreme Court, though, didn't then go on to lay out a very specific alternative rule or present a hard and fast test here. Instead, the court said, look, this is always going to be a very fact-intensive inquiry, but under the circumstances here in Upjohn, the communication of these lower-level employees in the foreign subsidiaries to the corporate attorney were privileged. And the court set forth specific things that influenced its decision here, including number one, the communications at issue were made by Upjohn employees to counsel for Upjohn, acting as such, right, at the direction of corporate superiors in order to secure legal advice from that counsel. Number two, the communications concerned matters within the scope of those employees' corporate duties, and the employees themselves were sufficiently aware that they were being questioned in order that the corporation could obtain legal advice. And three, pursuant to explicit instruction from the chairman of the board, those communications were considered highly confidential when they were made, and they had been kept confidential by the company all along. And then lastly, I have on this slide another factor that almost certainly influenced the court here was that the information sought by the attorney in this Upjohn case was in fact not available from upper level management, not available from the people that would have been considered in that control group. And the court's analysis here does seem right on, I think. After all, at least some of the time in certain circumstances, low and middle level employees, as well as those controlling officers, are going to be the ones who are going to have the information a company needs in order to seek legal advice in whatever situation they're in. All right, but looking at what the court didn't resolve in Upjohn, the court explicitly left open an issue that most people wouldn't have even thought was in doubt before. But the court explicitly left open this question of whether statements by former employees about their work while they were corporate employees made to the corporate attorneys, whether those statements would be privileged. Before the Upjohn case, most people would have assumed those disclosures certainly were not privileged once those people were not employees anymore. But the court explicitly said, yeah, we're not actually deciding that issue. So that issue is still an open question. The court, though, does in Upjohn suggest some guidelines that lawyers representing corporations should follow to try to ensure that information is going to be protected by the privilege. First, lawyers should ensure that the corporation directs the employees to provide the information to the attorney. Second, attorneys should ensure that the employees know that the purpose of the inquiry is to obtain legal advice for the corporation. 3, the employees should certainly be instructed to keep the information strictly confidential. And then lastly, number 4, you should ask only for information that relates to matters within the scope of the employee's duties. Now that last one seems pretty important. Certainly very strong hints there in the Upjohn opinion that the court expanded this privilege protection only when absolutely necessary to gather information that is within the scope of those lower level employees' regular duties. So an example that you might see, let's say you have a secretary in a company who looks out the window, witnesses a company truck run over a pedestrian. She is not going to be covered by the attorney-client privilege under the Upjohn case if she tells the corporate counsel what she saw, that she saw the company truck run over this pedestrian, right? Whereas anything the truck driver says to corporate counsel, now that is going to be covered. So, again, that illustrates this difference of something that does relate or doesn't relate to the scope of that particular employee's regular duties. All right, next we have the crime fraud exception to the attorney-client privilege. This is a pretty easy one. If a client seeks advice or help from a lawyer to facilitate or perpetuate a crime or fraud, those communications are not protected. So remember that this exception to the privilege only applies to communications made in furtherance of a future or an ongoing crime or fraud, right? Because our system obviously does protect communications about a past crime or fraud. So even though this is an easy definition to memorize, this exception can actually be a pretty hard one to enforce. I mean, first, because no one might ever find out about breaches of this, but also there's a certain circularity in the route that a court has to take to determine whether a particular communication with a lawyer was made in furtherance of crime or fraud, right? In order to do that, a court has to obviously know, well, what was the communication? But that communication might be privileged. So paradoxically, to figure out whether the privilege applies, a court might have to breach the privilege. And you read the U.S. v. Zolan Supreme Court case from 1989, a really fun case because it's a Church of Scientology case, a perfect case for the court to grant cert on. So what we had here, tape recordings of meetings between Scientology representatives and their lawyers, and the IRS here argued that these tapes fell within the crime fraud exception. And the IRS had affidavits, in fact, from an undercover agent who listed all the reasons that he thought these tapes were relevant. And of course, as you saw, he even provided a partial transcript of the tapes in the case. So there were a couple of issues raised in the Zolan case. First, whether it should be allowed for judges to actually examine allegedly privileged materials alone in chambers to determine whether the crime fraud exception applied. And then secondly, if that was going to be allowed, well, what preliminary showing should have to be made before a judge can decide to go back in chambers and do that? Can a judge just decide to rake through a bunch of materials whenever he or she wants to, if there's even the slightest suggestion that a communication was in furtherance of crime or fraud? So as you saw, the Supreme Court held, well, yes, judges do have discretion to view materials in camera, right? In camera, alone in chambers. There are actually 2 levels of proof that apply to this whole process, though. So the first question is, what preliminary showing should a judge require before making a decision to grant in-camera review. Does that preliminary showing have to rise to the level of, say, preponderance of the evidence, a Rule 104A type standard? And the answer to this first question is no, the preliminary proof doesn't have to convince the judge by a preponderance of the evidence. If the information provided, aside from those communications themselves, if that information presents a factual basis adequate to, quote unquote, support a good faith belief by a reasonable person that review in camera will reveal a crime fraud communication, then a judge has discretion to go forward and do that in-camera review. So this initial threshold determination is made under a 104B type standard, right? Enough to support a good faith belief by a reasonable person. The judge, of course, doesn't have to do it, though. There are factors the Supreme Court says the court should and can take into account, like how important this evidence is to the case, how voluminous are the materials that the judge would have to read. So those factors can go into that initial threshold 104B type determination. But then, if the judge does decide to go ahead and review those communications, the preponderance of the evidence standard of Rule 104A then does kick in. And if the judge decides after that review that there is more than a 50% chance that those communications were in furtherance of future or ongoing crime or fraud, then the judge can allow them into evidence after declaring them to be not privileged. But if the judge is personally only 49% convinced, then the party arguing against the materials being privileged loses, since that's the party with the burden of proof here. So the materials would be excluded as privileged. Now, the Zolan opinion also discussed what materials can be used in making that preliminary showing to convince the judge to do the in-camera review. In the Zolan case, we had that undercover agent offering partial transcripts of the meetings that were clearly obtained by subterfuge of some kind, right? So the Supreme Court says, look, it's okay to use information obtained through a leak, obtained through subterfuge of some kind, but the information used can't have already been determined to be privileged. And that undercover work or the leaking of that material can't have been illegal. So you wonder really if either of those should apply under the Zolan facts themselves, right? But the Ninth Circuit Court of Appeal on remand in this case did look through the transcripts, and on those alone, the appellate court ordered the district court to admit all the communications. And the Ninth Circuit remand opinion itself doesn't really go into the issue of whether the undercover work here was legal or not. So it kind of seems like the courts really dodged the issue here in the Zolan case. But the fact is, like I said before, without a leak or subterfuge that occurred like in the Zolan case, this is the kind of thing that is nearly impossible to find out about at all, which reminds us of a violation of the Brady laws in criminal cases. For those of you who are familiar with that, the requirement of prosecutors to turn over potentially exonerating information that they come across. It's very, very difficult for criminal defendants to discover that prosecutors have violated that Brady violation, again, because the information might be just kept secret by a prosecutor. Okay, this is the end of the video on the basic attorney-client privilege. The next video is going to talk about the work product rule, which is a companion to the attorney-client privilege.